Good evening, everyone, and welcome to the lecture series of CLAT preparation. In the previous lecture, we have discussed about the essential elements of the contract. We have talked about what exactly is offer, what exactly is acceptance, what exactly is a proposal. Proposal and offer means the same thing. Then we have talked about who is actually the promiser, who actually is the promisee, and how actually the agreement, when it is enforceable in the uh, law, is considered to be a contract. In this particular lecture series, we are focusing over legal reasoning. We have discussed what are all the subjects that one has to go through while they are preparing for the CLAT examination 2023 and other examinations which is related to law. And in this particular lecture series, we will be focusing only over those subjects which is related to uh, CLAT examination. And specifically in that particular CLAT examination, we are talking about legal reasoning. There are five major divisions of CLAT examination, starting from general knowledge, English aptitude, legal reasoning, logical reasoning, and quantitative aptitude. So, in the legal reasoning, there are various subjects that one has to study. We have to study the Indian Contract Act that we are currently going with. Then we will be focusing on the Indian constitutional law. After that, we will be talking about the Indian uh, penal code, the criminal laws that are there. After that, we will be discussing about the intellectual property rights. Post that, we will be discussing about the intellectual property rights, the rights that has been created by the intellect or the mind of the person, how to protect those rights. And after that, we will be discussing about the important case laws. So continuing with this video, we are going to discuss today some of the most essential requisites of a contract. As you already have knowledge and have already been informed that if we understand in the layman language, contract is nothing but a promise that has been made by a person which can be enforced in the court of law. And for that promise, the other person to whom the promise has been made is also willing to do a certain act or abstain from doing something, or rather, it can be said that he is also promising to do a certain act. So, summarizing it, we can say that reciprocal promises between individuals or legal entity is considered to be an agreement. And when that particular agreement is enforceable in the court of law, then that particular agreement is considered to be contract. Starting with this particular lecture, we will be focusing our mind over the three important aspects of Indian Contract Act. Some important sections that one has to remember while they are preparing for CLAT examinations, specifically in contract. The first and the foremost is section 2, which is talking about the interpretation clause that we have already discussed in our previous lecture. The formula for the mnemonics for remembering that particular section is P for car, V, C, V, V, where which 4 P's stands for proposal, promise, promiser, and the promisee. As you know that we have already discussed about what is the proposal, what is a promise, what is a promiser, and what is a promisee. I would just like to give you a quick recap so that we can come to the same pedestal where which we can start with this lecture. The proposal or the offer is right now in front of the screen, and we have already discussed it. So according to section 2A, section 2A of what? The section 2A of Indian Contract Act 1872. The legislation that was created, I will just show it to you. We are talking about this particular Indian Contract Act. So under the Indian Contract Act 1872, there are various sections that has been enumerated. So section 1 as talks about the short title, commencements and everything. Section 2 talks about the interpretation clause that we have already studied. Section 3 talks about communication, that the communication should be intended. Here we need to understand, and the only thing that we need to remember is that mere silence by the acceptor when given any proposal does not amounts to acceptance. It amounts to acceptance. Does not amounts to acceptance. So when we are talking about communication under section 3, what we need to understand is that there should be an intention to communicate about accepting the proposal. Moving forward, so now we have understood and we have thorough knowledge that what exactly is a proposal or offer. So offer is nothing but a person who has signified his willingness to do or not to do something in return to get the approval of the other person. Example can be X, or let's take the name again, Ram. Ram wants to sell his watch for rupees 5,000. Y or Shyam was communicated by X that I have my willingness to sell my watch for rupees 5,000. Are you willing to purchase it? Y says, yes, I want to purchase your watch. So here X is the offerer who is giving a proposal or offer to Y. So Y is a person to whom offer was made by X. So we have understood that whenever we are talking about any sort of proposal that has been given by any person, that particular person becomes the offerer, and the person to whom it has been made. Here in this particular instance, Ram will be considered as offerer and Shyam will be considered as acceptor or offeree. So the person who is to whom the offer has been made is known as offeree. And why do we call X as the offerer? Because he has signified his willingness to do or to abstain from doing something. What he is doing? He is doing something. In this particular scenario, he is doing something. What is he doing? He is going to sell his watch for rupees 5,000. And in order to sell his watch for rupees 5,000, he has conveyed his willingness to Y. So that is why he has become the offerer. In the same way, when we talk about proposal, this is the proposal, and when it is being accepted, according to section B, when a person made a proposal to another, to whom proposal is made, a proposal is assented thereto. So when X, Ram, has given Y his willingness, or what we say offer, to do something. And what is that? To sell his watch for a consideration of, or if I say for an amount of rupees 5,000. And if Y accepts it, that I am willing to purchase your watch for rupees 5,000 after X has communicated his offer. Please understand here, it is very important that only after of proposal has been made, then only offer can be accepted. Why we need to understand this is because if we take this instance again, if we take that instance again, and let's take the example that X is a person who has a watch. Okay. Now he has a watch. He wishes to sell his watch for 5,000 rupees. But he has not conveyed it to Y. He has not conveyed it that I am willing to sell my watch. Although he is willing to sell it, but he has not conveyed it to Y. He has just made up my mind that I am going to sell his watch. And at the same time, Y approaches X, says to him that I am willing to purchase your watch. For 5,000 rupees. So here it will not be considered that there is a promise, that there is an acceptance. Why? The question is why. Question is because this particular person X has not made the offer yet to Y. Rather, Y is willingness. Y has showed his willingness to purchase the watch that belongs to X. And here, so if we can understand, if we can differentiate between the two examples that we have given, here Y is making the offer and not X. Had it been the scenario that X has made the offer and Y would have accepted it, then Y would have become the offeree or the acceptor, and X would have become the offerer. But in the second instance, what we are seeing is that here X had the watch, but he never wanted to sell his watch. Although he might have in his mind his willingness to sell his watch, but he has not communicated his willingness to sell the watch to Y. But Y has communicated his willingness to purchase the watch of X for the same amount. So here it is Y who has become the offerer and X the offeree. Now it is upon the discretion of X that whether he is going to sell his watch to Y or not. If Y accepts, yes, I am willing to sell my watch to you for rupees 5,000, then Y will have to do the act of sending rupees 5,000 to X, and X is supposed to provide watch to Y. So here what we have understood is that it becomes very important to understand that whenever there is a proper proposal and proper acceptance, it needs to be communicated. Just by merely assuming or merely thinking in the mind without communicating that I wish to do something or want to abstain something or to abstain from doing something, in order to get the acceptance, in order to get the approval, or in order to ask the other person to do something or to abstain from doing something, that becomes only possible when that particular information of the offer is communicated. And that is why it becomes very important to know that how the communication takes place whenever we are talking about contracts. It is very essential to understand that what exactly will be considered as communicated. So I'll give you an example so that you can just brainstorm and can figure out that whether you have understood the concept or not. I'll give you an example. That is in 2023, X, or let's take then another name, because if we have used X a lot of time, it might cause confusion to you. So let's take a name, Rahul. Okay. So Rahul has communicated through email that to whom? Let's take another name, Rahul and Raj. Okay. So Rahul has communicated through email his offer that he wishes to buy Raj's house for rupees 50 lakhs. Clear? So what we are doing is we are trying to understand that how the offer is being communicated and what exactly is the procedure here. Okay. So when we are talking about offer that has been communicated by Rahul to Raj via email, stating that he wishes to buy Raj's house for rupees 50 lakhs. Now, here offer has been made by Rahul. Rahul has made the offer to Raj. It is said that an offer, acceptance, or revocation, what we are talking here is, we are talking about section 3 of Indian Contract Act 1872, which talks about communication. Communication of what? Communication of what? Communication of offer, acceptance. And there is one more word that you will be studying in the later phase of this lecture series, and that is revocation. So if we talk about revocation, revocation is nothing but cancelling of offer or acceptance by the person making the offer or accepting the offer. So this particular revocation is nothing but cancelling of the willingness or denying to do that particular act that was earlier promised. So often it happens that initially people think that yes, they are willing to do that particular act in order to get the assent or the willingness of the other person to whom they are communicating. In this particular example, that Rahul is willing to purchase Raj's house for rupees 50,000. He has communicated this particular fact to him via email on 20th November 2023. Let's take this example. On 23rd of November 2023, Rahul makes an offer to Raj that he is willing to buy his house for rupees 50,000. Now, Raj has two options. Either he can accept the offer that has been given by Rahul. Second, he can deny that I don't want to sell your house. Or third, he can alter the terms. Yes, these are the three requisites that can be made only possible by Mr. Raj if there is any sort of offer. So what we need to understand here is that whenever the offer has been made by a person to other person with a willingness to make sure that the other person is doing something or abstaining from doing something. So here, what we are expecting Raj to do, that if he wants to accept the offer that has been given by Rahul, he can accept by saying, yes, I am willing to sell my house. Second, deny. He can say, no, I don't want to. And third, he can say that I want to sell for rupees 1 crore. So in the third instance, first instance, it is clear that once offer has been made by Mr. Rahul to Raj via email communication, that particular email communication by Rahul in 2023 on 20th November is showing what? Is showing offer. Now Raj, if accepts it, if he accepts that yes, I am willing to sell my house for rupees 50 lakhs, then this will become acceptance. And when offer is being accepted, it becomes what? It becomes a promise. So now Rahul is promising to pay rupees 50 lakhs and Raj is promising to give the ownership of his house to Rahul. So we have understood that once we have initiated an offer by a communication, and once that particular information has reached the offeree, here in this particular instance, Raj is the offeree to whom the offer has been made, and Rahul is the offerer. So once the information has reached, the offerer has read the information, then only he can accept it. So it's very, very logical to understand that until unless the offer has not been communicated to the offeree, the offer has not been communicated from the offerer to the offeree, he cannot accept it. Until unless there is no offer, can it be accepted? No. The answer is clear no. Once it has to be an offer, then only it can be accepted. So we are very much clear here that offer can only, the first point that we can understand, but we can get a clarity here is under section 3, if we are talking specifically, which talks about communication of offer and acceptance. And what is the need of understanding that? Because until unless we are not sure how we are going to communicate our offer and acceptance, just by merely thinking that I want to sell my house for 10 lakh rupees to Raj, or I want to sell my house to XYZ person, it won't consider to be an offer until unless that offer has to be communicated. So under section 3, it tells us that how the communication is going to take place. And the first and foremost thing that it has mentioned under section 3 of the Indian Contract Act 1872 says that there should be an intention. How we show that intention? We show that intention by communicating to the other party that yes, it is my intention or I have the willingness to do this particular act so that I can get something in return from you if you have the willingness and the interest to do that particular act. So that is why the intention that we are going to study in section 10 also, the intention becomes very important. So here, intention is how the intention is shown. The intention is shown by Rahul when he sends this email to Raj. So what is he doing? He is typing the mail. He is sending the mail to Raj stating that, see, I want to purchase your house for rupees 50 lakhs. Are you willing to sell your house to me? This is offer. Now, one more thing that we will like to remember here is that let's take the time. This is a date, and why I'm mentioning the date and time, I will just let you know. And the time is morning 8 o'clock. So morning 8 a.m., Rahul emails to Raj stating that I wish to purchase your house for rupees 50 lakh rupees. Please let me know whether you are willing to sell that house to me or not. And now this particular scenario clearly shows us that offer has been made. Offer has been made. How are we going to check that? We are going to check whether Rahul had the intention. Yes, Rahul had the intention. How we can clarify that? We can clarify that because he has emailed his intention to Raj. Now, what is his demand is, what is his willingness is, that I am willing to give you rupees 50 lakhs. I will pay you rupees 50 lakhs as consideration if you give me your house. So what is he doing? What is Raj doing? Just raise it for you to better understand. So what exactly is Rahul doing here? Rahul is showing his willingness to do something. And what is he doing? He is willing to give rupees 50 lakhs. So Rahul is willing to give 50 lakh rupees. So this is what he is willing to do. And why is he willing to do? On this particular condition that Raj sells his house to Rahul. So what now we have a little bit of clear understanding here that, and let's also understand the terms that was written under the section of offer, which explains section 2a, which clearly demarcates what exactly is offer. So it is saying, according to section A, when a person made a proposal, when he signifies to another his willingness to do or abstain from doing something in order to get the assent of other person. So that willingness and that act of Rahul is clearly demarcating that he has made the offer. And as already told to you that that offer was made by Rahul via email communication, and that offer was communicated, and how this communication took place. Once offer has been communicated, when is it being communicated? Answer is when it is in the knowledge of Mr. Raj. So now let's take example. I have sent the email, that Rahul has sent the email to Mr. Raj saying that I wish to purchase the house from you for rupees 50 lakhs. But Raj is not available on email. So whether the offer can be said to be communicated, the answer is no. Offer can only be said to be communicated to the person to whom it has been made once the person gets the knowledge of that offer. So offer is communicated when, according to section 4, we are talking here of section 4. Section 3 says that communication of offer and acceptance should be intended. There should be an intention to communicate the offer and acceptance. and revocation also. But here we are only limiting ourselves to offer and acceptance. And when we are talking about offer being accepted, and when will it be accepted? It will be considered to be accepted when it comes, or rather I would say when the communication of the offer is complete. When the communication of the offer is complete according to section 4 is when it comes to the knowledge of the offeree, or in our example it is Mr. Raj. So once Raj comes to know that Rahul has communicated to me that he wishes to purchase my house for rupees 50 lakhs. So now this particular knowledge of this offer by Rahul to Raj is considered to be communicated. So the offer has been communicated and has been completed. So now, first step, the very first step of a contract, that is offer, has been communicated or complete. So this is the first step. The first step has been taken. Now what should be the next step? If Raj wants to purchase the house, we are taking the example, if we say that Raj wants to sell his house. So if Raj is willing to sell his house, what he will do? He has two options. Either if he has the contact details of Rahul, he will communicate via telephonic communication that yes, I am willing to sell my house to you for rupees 50 lakh rupees. We can come and we can just negotiate over the terms and conditions, and I will transfer the property. But had it been the scenario that Raj is not at all willing, so if Raj is not at all willing to to sell his house, he will deny it. And the moment it has been denied, the offer stands to be rejected. And when the offer stands to be rejected, it means the contract or the agreement never existed. Yes. So if it is denied, I don't want to sell my house. So it will be considered as rejected and denied, and there will be no agreement as such. There will be no agreement as such. This is section 4 we are talking about. There will be no agreement as such. But now let's take an example that Raj wishes to sell his house. There can be two instances. First is Rahul wishes to sell his house for the same amount which Rahul had made. Rahul wanted to sell his house for rupees 50 lakh rupees. Rahul wanted to purchase the house of Raj for rupees 50 lakhs. So now Raj can say yes. And now again the question will be, how will Rahul come to know that Raj is willing to sell his house? Question is, how will Rahul come to know? The answer is, once the communication is being made, in this case, Raj emails or calls, meet, anything which ensures that Rahul has the knowledge of acceptance of the offer made. Rahul has the knowledge. So once Raj communicates either via telephonic communication or via email or by meeting in person, by verbally or by sending a letter that yes, I want to purchase your house for rupees 50 lakh. I want to sell my house to you for rupees 50 lakhs. Then we will say that the offer has been accepted. Offer has been accepted. So the offer has been accepted, once the offer has been accepted, Raj and Rahul will have obligations. Rahul will have obligations. So now take an example that Rahul communicates to Raj that I want to purchase your house for rupees 50 lakhs. But after a certain period of time, when Raj comes to know, so for example, Rahul has communicated this particular intention of his that I want to purchase your house for rupees 50 lakhs on 20th of November 2023 at around 8 o'clock. He informs his via email communication. Now, Raj opens up his emails at 8:45 a.m. and sees that this communication is made. So once Raj has knowledge and it comes to the knowledge of Raj, Rahul will become bound or obligated that yes, I am supposed, and once it comes to the knowledge of Raj, now this obligation is mandatory, or Rahul will be obligated that he has to provide rupees 50 lakhs to Raj if on the condition that Raj will sell his house. Why is it needed? Why is it so important? And why is it so that we are studying it? Because in day-to-day life, if we see that majority of the time, whenever whenever this type of transaction takes place, house, if we consider this example only, house is a commodity, is a property that has been owned by any person, and that person obviously, if he has willingness to sell his house, he has to do a lot of arrangement. He have to relocate, he will have to move the property from, he have to move his commodities that is present in the house from one place to another, and lots of things will obviously be there. So it is necessary that the person whomsoever is making the offer are actually interested and they are actually willing to come into a contractual relation. And that is why here I would like you to write down a very important case law which is which is in relation to the offer and the acceptance. We are going to discuss two important case laws. The first is Balfour versus Balfour. Balfour versus Balfour. It is for 1919 case, and it is an English case. English case means that it was being heard by the English courts. And here, I'll just give you the facts that Balfour was the husband and Balfour, other Balfour is the wife. So what happened was that husband was going out for an official trip, and just without any intentions and without any without any obligations, he, out of love and affection, told his wife that I will be giving you a rupees $50 on monthly basis if you on monthly basis for your maintenance. And then he left off. And after a certain period of time, Initially, he gave that particular amount of maintenance, $50 every month, he used to pay to his wife. But after a certain period of time, he resented and he didn't pay that particular amount, because of which Balfour, the wife, suffered a lot of loss, and she went to the court, and she sued her husband, that now Balfour is not providing me the maintenance as he has promised, and there was a contract that was there, and obviously Balfour is supposed to make that particular payment to me. The court in this particular case mentioned that we have to see whether there was any intention to create legal obligation. Just merely saying, I want to sell my house for rupees 20 lakhs, 30 lakhs, 50 lakhs will not obligate you, will not force you to sell your house to any random person. First, you need to understand. We have to make sure that there is an intention that is being there by the offerer to do something, his willingness to do something. And the intention can be seen through acts. In this particular instance, the court observed that there was no intention by husband, but a surety out of love and affection. So there was no intention, but there was only a surety out of love and affection by Mr. Balfour to Mrs. Balfour, that I will pay you a requisite maintenance amount of $50 every month. But after a certain period of time, he never made that particular payment, and Mrs. Balfour sued him, obviously. But since there was no intention, it was not neither it was written and neither it was communicated with that particular intention. So the court observed that this is not enforceable because there was no legal intention to come into contractual relations. You can correlate this particular point in such a way that majority of the times your parents would tell to you that if you will study for 3 hours or 4 hours, we will definitely allow you, we will obviously take you out to a good place, or we will offer you a treat. And these type of commitments that is arising out of love and affection cannot be considered to be a contractual relation, because there was no intention. We cannot show to the court that there is any sort of intention. So that is why it is very important that there should be intention. As already discussed under section 3, we talked about intention is a very important phenomena whenever we are talking about contract. And the second one, and the totally opposite of the same example, is merit versus merit. So these two case laws are considered to be counter of each other, and the important difference between these two case laws is the intentions. Here, in Balfour versus Balfour case, we saw that there was no intention of the husband, and it was only out of love and affection. But in merit versus merit case, Mr. Merit gave in writing that he will pay maintenance to his daughter every month. Now, as you can see, we can understand that if the person is writing, if he is showing his willingness and his acts are actually such which can be considered to be an offer, that particular agreement has the intention, and that intention clearly demarcates that the person are willing to enter into a legal obligation. And that is why intentions plays a very important role whenever we are talking about creation of agreements which can be enforced in the court of law. Now we have understood that there should be intention, and for the intention we need that there should be a proper communication. That proper communication has been mentioned under section 3 and section 4. Section 3 talks about that we should be having intentions to enter into a legal obligation, and that is why the communication should be such that the intention should be properly conveyed. And after that, section 4 talks about communication when complete. So in the case of offer, we have understood that the communication will be considered to be complete once it has been communicated to the offerer and it comes to the knowledge of the offerer. So of the offeree. So offerer makes offer to offeree. Rahul, offerer, Raj, offeree. Once it comes to the knowledge of offeree, offerer becomes obligated. Offerer becomes obligated once it comes to the knowledge of the offeree. And now, if offeree also has to be made obligated and bound by the terms. And here the terms are that sell me your house for rupees 50 lakhs. And offeree, now Raj also communicates that yes, I wish to sell my house to you for rupees 50 lakhs. So if this communication he sends via mail to Rahul and at 8:47 saying that yes, I accept your offer. 8:47 a.m. Yes, I accept your offer. Then from 8:47 a.m. onwards, Raj will also be obligated by the terms, meaning which he will also be obligated to sell his house to the offerer, and the offerer, that is Rahul, once he reads that mail, let's take the example, he reads the mail at around 8:50. So the moment Rahul comes to the knowledge, it becomes an agreement. Yes, is it clear? So now both the people who have conveyed their willingness to do something and not to do something to the other person, the moment the offerer gives his willingness and the offeree tends to get the knowledge of that offer, the offerer becomes liable. And when the offeree conveys his acceptance to the offerer, the offeree becomes liable. And once the offerer comes to know about the acceptance of the offer by the offeree, the whole transaction becomes an agreement. Because what we have studied in agreement? An agreement is nothing but a reciprocal promise to do something or not to do something. So offerer he has giving a promise. What is he making the promise of? That I want to purchase your house. by giving you rupees 50 lakhs, and offeree says, yes, I will give you my house, I will sell my house to you if you pay me 50 lakh rupees. Clear? So in the second instance, the first instance, we understood that, okay, fine, the obligation of the parties will only be there if there is an acceptance. If the acceptance has been denied in the very first instance when the offer was made, the agreement is not at all initiated and it has been rejected. But if the offer has been accepted, when the obligation will arouse, when it will be considered that yes, the parties has communicated their acceptance, or the parties has now been obligated by the terms, it is when it comes to the knowledge of the person to whom it has been made. And here we need to understand also one more thing, that time is very important in this particular instance. I have only communicated this information to you while taking an example of the year 2023, because we need to understand that how the communication takes place. Now, other example, so that it becomes very clear to you. Okay, so let's take the example again, so that it becomes crystal clear for you to what exactly how the communication will be completed and how the obligation will start arising between two individuals. Okay, so now we have understood that this was Rahul, and there was Raj, and let's draw them for your better understanding. Okay, let me take some another color. So now this is Raj and this is Rahul. Rahul conveys to Raj rupees 50 lakhs if you sell your house to me. And Raj sends, okay, I accept. So this is the promise made by Rahul. This is the promise made by Raj. These are what? This is a promise to get this promise in return. That is, Raj wants to give his house and Rahul wants to give 50 lakhs. So what is it? It is reciprocal. The promises are reciprocal. So whenever there is a reciprocal promise, what does it constitute? It constitutes an agreement. This is very much clear that now the offer has been communicated and it has been accepted and everything is fine. And now the information has been communicated. Now let's take one other example. That example will help you out in understanding that there is one small difference, and that is also we will understand it by taking examples of day-to-day life routine. Now, it has been often seen that post-communication, we tend to understand that, okay, we have communicated our willingness to do this particular act. In this particular example, Rahul has communicated that I want to purchase Raj house for rupees 50 lakhs. Now, after a certain period of time, and he has communicated this particular information to Rahul, Raj, let's take the example of at 8:30 a.m. So at 8:30 a.m., he has given his offer via email communication. And post that, Rahul feels that I should not be purchasing this particular house for rupees 50 lakhs because there are chances that I might get this same house of the same quality, maybe for rupees 30 lakhs also. Until now, till this particular time period, Raj has not seen the message. Has not seen the message. And after understanding that I should not be providing this particular, I should not be offering to purchase the house for rupees 50 lakhs, I should inform. So at 8:31 a.m., Rahul again sends the offer saying that I want to purchase a house for rupees 30 lakhs. Okay. So in the first email, he is saying 50 lakhs. Now he is saying 30 lakhs. So if this type of communication is taking place, so which will be considered as an offer? Whether this will be considered as an offer or this will be considered an offer. We have to see that the latest communication that takes place constitutes offer. So here at 8:31, if Rahul communicates that I want to purchase your house for 30 lakhs, Raj cannot claim that he will sell his house for 50 lakhs because it was communicated by Rahul initially. Because at that point of time, Rahul was not obligated to do the payment of rupees 50 lakhs to purchase the house of Raj, because it was, although it came to the knowledge of it was in the email box of Raj, but Raj has not seen that mail so far. So it means that Rahul has not become obligated by his own offer. Had it been the scenario that at 8:30 only Raj would have seen the message, then Rahul would have been obligated to pay 50 lakhs had Raj would have mentioned that I accept your offer. But at 8:31 a.m. he says that I want to purchase a house for about 30 lakh rupees. So now it is Raj who wished to see that whether he want to sell his house for 30 lakhs or not. And if he says to Rahul that no, I don't want to sell my house, so the offer will be rejected and the offer and the agreement will not be there. The moment after getting the email communication, the moment Raj sends his acceptance, Raj sends his acceptance via email communication only. Okay, that okay, fine, I am willing to sell my house to you for rupees 30 lakhs. And after sending the email at 8:31 a.m., 8:34 a.m., Raj again gets a little bit confused and he rethinks that I don't want to sell my house as of now because there is no point of selling the house. So now the communication has already been sent to Rahul. How is it so? How is it so important? How is it so possible that Raj can be relieved from such an obligation? So if Raj conveys to Rahul before Rahul coming to knowledge of the acceptance. So here, if Raj sends his acceptance at 8:34 to the email communication that was made by Rahul at 8:31 that I wish to purchase a house for 30 lakh rupees. And Raj at 8:34 a.m. sends the mail. But was not seen by Rahul, meaning which knowledge of acceptance wasn't there. Raj can revoke his acceptance, meaning which if Rahul has not seen the message, Raj at 8:35 or any time after sending his communication, he can send the mail at 8:35 stating that I don't wish to purchase your house. And once Rahul will open his email and he will see both the message, it is clearly understandable that the offer was initially accepted and then it was rejected. And that is why the obligation over Mr. Raj is not there. Why we need to understand that? Why is it so important to understand that when it can be considered that the offer has been accepted or not? Because once the obligation is there over the parties, they have to perform certain tasks or certain work according to the terms and conditions of the agreement. In this particular example, we have talked about that he was willing to sell his house for 30 lakh rupees. So the moment it comes to the knowledge of the acceptor, that is Raj. So Raj can initiate a proceeding against Mr. Rahul that yes, I had accepted the offer and I had sent him my acceptance, but now he is not willing to purchase my house. So you can even force a person to perform his duty to make the payment of rupees 50 lakhs or 30 lakhs, whatsoever be the amount, if they have informed and the offer was communicated to them. But if Rahul would have, under this pretext that now I don't want to purchase my house, then what? So if Rahul initially would have given his offer to purchase the house for 50 lakhs, 8:30 a.m. and then he sent a message of revocation that I do not wish to purchase, and it comes to the knowledge of Raj before his acceptance. So before his acceptance, Raj has still not accepted the offer. Raj has still not accepted the offer, and he comes to know that initially he wanted to purchase 50 lakh rupees, but now he has rejected. So he cannot bound Rahul to perform that particular act because Rahul has revoked his offer. So Rahul initially wanted to purchase the house, but now he has no willingness. So now he has rejected the offer, and that is why it has been considered that the offer has been rejected. I suppose I was able to make you people understand and aware that how the communication is taking place, and when the communication is considered to be accepted, and when the communication is considered to be when the condition is considered to be when the communication is completed. So section 4 we have understood. Section 4 of the Indian Contract Act, which talks about communication is complete. And I suppose you have now thorough knowledge of how that offer is being communicated to from the offerer to the offeree. And it is very important for the offerer or the acceptor or the offeree to have the knowledge of that particular offer that is being made and how the acceptance is being made. You can go through section 4 on the bare acts that is being present. This is the bare act to which I'm talking to, and kindly go through section 4. After reading section 4 and going through the illustration that has been mentioned, I'll give you one illustration that has been mentioned under section 4, which section 4, which talks about A proposes to sell his house to B at a certain price. The communication is complete when B receives the letter. The communication of what? The communication of proposal. So we need to understand that while we will be talking about the essential elements of the contract, these are the essential elements: offer, acceptance, intention, consensus, idiom, consideration, capacity, free consent, legality. So the very first thing that we need to understand is offer and acceptance, that we have already studied. But how will we ensure that offer is communicated or acceptance has been communicated or acceptance communicated? So for that, we needed to understand section 4. Section 4 talks about acceptance, offer, and revocation. Till what time we can reject the offer that has already been given approval or acceptance from our end, until what time the offer can also be revoked, that we have understood. Now from the next lecture onwards, we will be focusing our minds over the essential elements of the contract, of essential elements of a valid contract. And once you have been acquainted by this essential elements of the valid contract, we will be focusing our mind over the important requisites of a person to enter into a contract. How a person can be understood that he has the capacity to enter into an agreement. The capacity to the contract, that is very important for you. Consensus ad idem, that is known as the meeting of the mind. We will be studying about that also. Offer we have studied, acceptance we have studied, how the offer and acceptance has to be communicated, that we have studied. Now we will be talking about intention to create a legal relationship, that has been studied under section 3. We have talked about offer. Offer has been mentioned under section 2A, which talks about proposal. Acceptance means accepting the offer. And then after that, once we are clear with that, we will be talking about the free consent, what exactly the lea object, and whether writing and registration is important. So I would like to tell you here that in Indian Contract Act, a contract can be both verbal as well as written. There is no essentiality. There are certain documents, certain agreements which needs to be registered, and it has been clarified, it has been given approval by the government that these particular set of documents has to be registered. For example, we're talking about rent agreements. So rent agreements needs to be registered. But when we talk about other agreements, for example, selling of the house or maybe purchasing purchasing a bicycle or maybe purchasing a mobile phone, there is no need of contract. There are general contracts or general offers that is there, and obviously we'll be studying the different type of offers in our lectures to come. But in our next lecture we will be talking about the essential elements of the valid contract. We have completed section 1, section 2, section 3 and section 4 of the Indian Contract Act. Section 5, 6, 7 are perhaps not very important in terms of your CLAT examination. Section 7 talks about section 8. So section 8 and talks about offer by performance. And there are two important case laws that we will be studying in that particular section. The first the first case law is Lalman Shukla versus Gauri Dutt. And then there is one more case of Carlyle versus Carbolic smoke ball case. So these are the two cases that we'll be dealing in our coming lectures. With this, I would like to end today's lecture, and I hope you the very best of luck. May you start preparing your examination, and please make sure that you are consistently practicing the previous year question papers to assure that you are well versed with the problems and how to tackle with the problems. Principles, I'll make sure that you are understanding in a very thorough and clear manner. Thank you so much, guys. Bye.